How many of you have based your decision to buy a home on colorful brochure and enticing lifestyle illustration? Many prospective house buyers usually have little knowledge of what aspect to look for when acquiring a home. After having made the requisite down payment, they wake up to realize that their sale and purchase agreement does seem different from the standard one. How do they get out from gotten committed? Let me challenge you to spot the differences between those under the housing law and those outside the purview of the housing law. Now, in this episode, I would like to enlighten you that not all apartments are the same. Call them what you like. Small office, home office, SOHO, SOHO. Small office, flexi office, SOFO, SOFO. Small office, versatile office, SOVO. Small office, modular office, SOMO, SOMO. Condotel, hotel suite, or butler service apartment. The names are coined by housing developers with creative plan to wow investors with enticing marketing tools on yet-to-be-built stratified properties. Where people used to buy an apartment unit parcel for a roof over their head, of late, so many styles have crept up to boggle the mind of investors and buyers. However, for the uninitiated, not all apartments are created equal. Although the sale and marketing brochures may look alike, the small prints will tell you the difference if you care to take a magnifying glass to inspect. Then again, for the first timer, they are unlikely to spot the differences. These videos aim to shed some light for those who have yet to decide on the various offers of apartment projects and for those who have suffered the fate of having bought into a problem. It is a good idea to find out the legalities, whether these developments are regulated under the housing legislation. How many of us have based our decision to buy a home on colorful brochures and enticing lifestyle illustration? Many prospective house buyers usually have little knowledge of what aspect to look for when acquiring a home. The construction of a housing project involves numerous parties and legislation, and when problems arise, help in any form is often time-consuming and costly. The onus is on the prospective house buyers to be educated on their rights and to seek help from all sources available before they make their first payment. Now, it is important the buyers know the rights and how to use them. The Housing Development Control and Licensing Act 1966 amended 2012, inverted commas Housing Act, controls the development of housing accommodation. Housing accommodation may not be same as what you think you are buying. Purchasers of service apartment and SOHO are often surprised when they have bought a commercial property. The Statutory Sale and Purchase Agreement (SPA) is Schedule H, building or land intended for subdivision into parcel, and Schedule I, build then sell 1090 concept for stratified property, pursuant to the Housing Development Control and Licensing Regulation amended 2015. Under the Statutory Sale and Purchase Agreement, some of the pertinent clauses for the protection of house buyers are as follows. 1. Date of commencement and completion. Generally, the date of the sale and purchase agreement is the date the contract takes place and is binding upon both the covenanting parties, the developer and the buyers. It is scheduled to be completed within 36 months from the date of the contract. It is a prerequisite that all building plans, layout plans, and the approval from the local council must be obtained before a housing developer is able to obtain the APDL, Advertisement Permit and Developer's License. Secondly, compensation for late delivery, commonly known as LAD, Liquidated Asset Damages, is calculated at a rate of 10% of the purchase price should the developer exceed the stipulated period of 36 months. Thirdly, manner of delivery of vacant possession. Delivery of vacant possession should be supported by a Certificate of Completion and Compliance (CCC) and includes the handing over of keys of the parcel to the buyers. Water and electricity supply are ready for connection to the said parcel. Fourthly, defects liability period. The developer is mandatorily required to warrant against defects, sinkage, and other faults in the parcel, building, and common property that may become apparent within 24 months after the date the purchaser takes vacant possession. Fifthly, stakeholder money. The retention sum against repairs and replacement is 5% of the purchase price and is kept by the developer's appointed lawyer stakeholders and to be released in 2 tranches. Sixthly, Schedule of payment of purchase price. Every stage of the work completed must be supported by a progress certificate signed by the developer's architect or engineer in charge of the housing development, and such certificate, so signed, shall be proof of the completion of the various stages of progress work. 7th, Tribunal for Home Buyers Claim. The Parliament has created the Housing Tribunal as an alternative platform for house buyers to seek legal redress. It is an easy, cheap and speedy alternative forum. Since it was to be a tribunal or court for the ordinary house buyers, numerous measures were taken to ensure that it was user-friendly and affordable, including a cap on filing fees at the nominal rate of 10 ringgit and keeping lawyers out. Non-statutory sale and purchase agreement are different. These non-standard SPA are drafted under the whims and fancies of those developers with their lawyers. Efforts are not spared to ensure that they are disguised with bold title appearing to emulate the statutory sale and purchase agreement, but with diverse terms and conditions embedded otherwise. It is not uncommon to find buyers stressed out and frustrated after having identified the differences between the standard and the non-standard sale and purchase agreement. By the time, the relationship between the developer and the affected buyer would have been strained and stained. Date of commencement of completion. At the time of sale and the date of the SMP, the developer often have not obtained the necessary approvals, be it building plans, floor plans, or the likes. The completion date is what is stated in the SPA, often between 42 months and 48 months from the date the building plans approval is obtained. Developers under this category are not licensed, thus not under the purview and jurisdiction of Housing Ministry, because they are not building housing accommodation per se. There is neither any requirement for an APDL nor need to comply with the Housing Act. Those built on commercial title will have to bear commercial rates of assessment, crate rent, utility charges like electricity and water tariffs. There are instances of housing developers constructing SOHO, small office, home office, that has been granted exemption from the Housing Minister, thus to be precluded from the ambit of the Housing Act on the pretext that they are developing commercial development. Secondly, for non-act sale and purchase agreement, compensation for late delivery, commonly known as LAD. It is often calculated at the rate of 10% on such portion of the purchase price as the buyer may have paid to the developer, where it exceeds the stipulated period of 42 months or 48 months as the case may be. Thirdly, manner of delivery of vacant possession. Delivery of vacant possession is often supported by the developer's architect's certificate of practical completion, not tantamounting to CCC. It does not give the buyer the rights to occupy the parcel until such time as a CCC is issued. Where there is no time frame to issue the CCC, it becomes meaningless and the buyer will not be able to plan his occupation. There's no provision for connection of water and electricity supply to the said parcel. It is sometimes at the peril and mercy of the utility providers. Defects liability period. Here, the warranty against defects, sinkage, or other faults in a parcel is often just 12 months only, after the date the purchaser takes vacant possession. There is often no warranties on the building and common properties. Fifthly, stakeholder money. What retention sum? There is none. All the monies are released to a developer immediately upon date of notice of delivery of vacant possession, whether the buyer takes physical possession or not. Sixth, schedule of payment of purchase price. Normally, all the installments are released to the developer on the commencement of works. No need to be certified. For example, 15% of purchase price is due to be paid to the developer when the developer commences earthwork at site. He will conveniently have his tractor scoop up the earth and hence commenced. He too will get another payment of 15% on commencement of his first piling and earthworks. Most of the projects fail in non-act sale and purchase agreement because they collect profit before completing the job. Their payment schedule are top-heavy, meaning they collect the bulk at the beginning, leaving less for the later stages of work. Tribunal for Home Buyers Claim. The tribunal is not available to the aggrieved buyers. Their legal recourse is through the court of law and they will have to argue within the four corners of the sale and purchase agreement. They cannot say they don't know. As the maxim goes, ignorance of the law is no excuse. You still do not spot the differences? I've in fact come up with a table for easy reading, those under housing law and those not under housing law. It will be on your screen. In conclusion, While there are responsible housing developers, there are equally a percentage who scheme ways to shortchange unwary and naive house buyers. It is to the interest of every house buyer to appoint his or her own lawyers, well-versed in conveyancing practices, to vet through the sale and purchase agreement to safeguard their own interests. In the case of unfriendly terms and conditions, don't buy. The prerogative is the house buyers to safeguard themselves through all means. Dr. Chung, I'm one of the victims of non-standard sale and purchase agreement where the so-called housing developers were building studio units 450 square feet in Petaling Jaya near the university. They promised that the unit can fetch 2,000 ringgit from the students where I can even cut into 2 rooms. The developer have since absconded after having collected nearly 60% of the payment as against 30% physical construction. I know I'm screwed. Yes, you're screwed. Yours must be a case of those projects which are not regulated under the housing legislation. The contract of purchase must be the type that are lopsided towards the developer, whereupon the progressive payments are made according to the schedule of payment that you have agreed to abide by. The Ministry of Housing will not be able to assist you because these developers are not licensed by the ministry. Your only recourse is to galvanize the affected buyers together and to approach a local council like MPPJ, MPSJ and Lembaga Perumahan Hartanah Selangor at www.lphs.gov.my with a view that they will convene a meeting between the developers, their architect, with your representative group to be informed of the way forward, if any. If the meeting has come to naught, you will probably have to appoint your own lawyers to seek legal recourse. My second question, Dr. Chang. My father has bought into a resort concept property, supposedly with all the club facilities and infrastructure completed with street lights and separate title deeds to our property some 15 years ago. My family now wish to build a house on the land but discovered that property developer did not lay all the necessary water, electricity and sewage main to serve the area, though they promised to do in the sale and purchase agreement. What should we do? Your father should take out the sale and purchase agreement contract, all sales brochure and correspondences for a litigation lawyer to read through. Thereafter, the lawyer will advise you on the legal avenues available to your father. Let this be a lesson to those trusting buyers who still think they want free legal fees when they purchase from their property developers. There are many pitfalls that await unsuspecting purchaser in sale and purchase transaction. One of the most serious one is the issue of legal representation. Who does the solicitors represent in a sale and purchase transaction? Just remember that the cardinal rules of conveyancing are each party to a transaction should engage his own solicitor, and a solicitor shall not act for more than one party in a particular transaction. Every party to a transaction needs independent and separate legal representation in order that his rights and interests are fully protected. If you think that you cannot afford the services of your own solicitor, then you should consider whether you can afford not to. The moral of the story is don't be penny wise, pound foolish. Don't try to save on legal fees and end up paying more if your rights and interests are somehow compromised. Thank you for the excellent questions. My next talk will be, would the proposed Residential Tenancy Act put an end to tenancy woes? Where I will talk on the legitimate interests of the landlord against errant tenants and protect the tenants against irresponsible landlords. See you in the next episode. Cheers.